Hello, and welcome to Horns of a Dilemma, the podcast of the Texas National Security Review, TNSR. I'm Doyle Hodges, Executive Editor of TNSR. William Tecumseh Sherman famously said, "War is cruelty and you cannot refine it." This phrase, often paraphrased as "war is hell," has come to define the view of many in regards to acceptable conduct in war. But in this week's episode of Horns, we explore the somewhat antithetical notion that there are rules that still define the conduct of war. That even within the context of an endeavor that is given over to killing, destruction, and harming people in order to achieve a political end, there are still certain ways of doing that that are out of bounds. Professor Derek Jinks of the University of Texas Law School discusses the evolution of the regime of international humanitarian law, which grew up after World War II and which defines the landscape of war crimes as we understand it today, including the mechanisms of jurisdiction and enforcement that translate what previously were rules only applying to states into rules that regulate the conduct of individuals and carry with them specific criminal liability. This is a timely and important discussion. Let's listen in.
Hi, everyone. Thank you for coming. I'm glad to see, but not surprised, that we have such a big turnout given what's going on in the world. I know this is on everyone's mind. We're very lucky that on our faculty, we just happen to have one of the leading experts on these topics in the United States and perhaps, and therefore in the world. Professor Derek Jinks, many of you, I'm sure, have taken his classes. If you haven't, after today, I'm sure you'll want to. He is the A.W. Walker Centennial Chair in Law at our own lovely University of Texas School of Law. He's also a senior fellow with my organization, the Strauss Center on International Security and Law, which is sponsoring the event here today. Professor Jinks researches and teaches on things like public international law, international humanitarian law, which we also call the law of armed conflict, international criminal law, another relevant issue today, human rights law, and just general criminal law. He has many interesting professional experiences. I won't recount all of them, but I do want to highlight one. He worked in the prosecutor's office of the International Criminal Tribunal for the former Yugoslavia. That's one of the ad hoc tribunals that was set up in response to a human rights calamity. In this case, obviously, the breakup of Yugoslavia, the wars in Bosnia and Kosovo, and the many human rights violations that were committed there. So he has a special perspective on the possibilities for accountability in war crimes, and of course is also an expert in the substantive law that governs these kind of offenses. He's written many books. Those include a forthcoming volume, appropriately, on international humanitarian law, which of course is the law of armed conflict, many, many other things as well. So you didn't come to see me. I'll stop there. I'll recognize Professor Jinks. He's going to talk for about 10 to 15 minutes. And then we'll have some comments from UT students who are also veterans and who have some professional experience with these topics. And join me in welcoming Professor Jinks. Thank you for joining us.
Thanks, Adam. I really appreciate it. You can take this seat, please. Welcome, everyone. Thanks for coming out. Our idea today is that this would be a Q&A session primarily. But in order to get the conversation started, I want to say a few things. As a general matter, I will sort of set the stage for what I think is likely to be the sort of topics that you would like to discuss. And if you don't mind, I think I'm going to remove my mask. It feels strange to be the speaker and maybe essentially the only person really wears the mask. So I will we'll remove it. So as Adam suggested, and likely what drew you here, other than the tacos may be the whole thing, right? You're getting the tacos and you thought, well, what is this guy going to talk about? But you're likely here because of how front and center discussions of war crimes that are alleged to have been perpetrated by Russia in its conflict with Ukraine, how central that's become. In discussions about the prosecution of the war, normative questions arising out of the war, all really centered on this notion of criminality, or at least increasingly centered on this notion of criminality. So what can we say here? Because I know that many of you likely have little to no background in this notion of war crimes. Likely connect up the ideas that it's crimes committed in time of war, but other than that, you might be at a bit of a loss. So here's the best way to sort of frame it. There are several critical post-World War II developments that really just fundamentally reshaped the international legal order. And they all occurred in a very compressed period of time. It's really quite a remarkable, brief period in the history of international law, beginning with the UN Charter in 1945, the IMT Charter that established what we now refer to as the Nuremberg Tribunal in 1946. In 1945 itself, the charter was in 1945. The trial and judgment, trial occurred, judgment issued in 1946. The Genocide Convention, 1948. Universal Declaration on Human Rights, 1948. The Geneva Conventions, 1949. And we have a small window of time, 4 years, in which we completely changed the way that we think about the international legal order. One critical development that occurred here, I mean, obviously there are a number of aspects of those developments that you might choose to talk about. Frankly, the crisis in Ukraine implicates and in some ways challenges all those developments, everyone. We're focusing on war crimes, so we're going to zero in on the Geneva Conventions case. It's really the start of the conversation about war crimes, about contemporary war crimes. But I do want to point out that there is a kind of conceptual shift in public international law that's reflected in some of these other developments. The idea that international law imposes obligations directly on individuals. Not simply that individuals can violate international law, but that when individuals violate international law, they might face, they might be formally assigned responsibility, could be formally assigned criminal responsibility. Individuals to be punished for violating international rules. In addition, international law is reconceived in a way that it explicitly protects individuals. So when we think of classical public international law, we think of rules that regulate the relations between states, the conduct of states intersect. Indeed, anytime an injury inflicted on an individual was to be raised on the international plane, the state of which that person was a national had to espouse their claim on the international plane. It was the state claiming, we have been injured by your conduct that injured one of our nationals. The idea was individuals really weren't the proper subjects of international law. Rights and obligations were assigned to states. One of the crucial shifts that occurs in Nuremberg, and you've all no doubt heard references to these appeals at Nuremberg, but one of the fundamental shifts was to take seriously the idea that wrongs, fundamental wrongs, when perpetrated on the international plane, are not committed by states. States are abstract entities. Fundamental wrongs are perpetrated by people. And the parties that are injured aren't states. States are abstract entities. The entities that are injured are people. International law, if it's to promote a liberal, rule of law driven conception of world politics, really needs to take seriously this notion that individuals have obligations, individuals have rights. Individuals are protected, individuals need to pay the price if we're going to take accountability seriously for the rules. And several of the developments that I just described really are sort of the centerpiece collectively. They are the centerpiece of those developments. So let's focus on the Geneva Conventions. So the Geneva Conventions of 1949 fundamentally reshaped the way that we think about international humanitarian law, or as Adam suggested, sometimes called the law of armed conflict. The idea is rules applicable in a particular kind of context, not rules of general application, rules of special application. The technical phrase that we use in the IHL biz is to say that they are rules with a delimited material field of application. That's a very lawyerly way of saying the rules only apply in certain kinds of situations at certain times. But what's the point of the Geneva Conventions? In that kind of context, the idea at bottom is to make clear that even in time of armed conflict, even when a party might be motivated by overwhelming claims of military necessity, fundamentally fair, fundamentally humane treatment must be accorded to persons who've been placed at the mercy of the enemy. The idea is to articulate a sort of humanitarian baseline. And the four 1949 Geneva Conventions do this. They articulate this fundamental humanitarian baseline with respect to a number of categories of vulnerable persons referred to as war victims in the Geneva Conventions. Terrifically important developments. But one crucially important development, revolutionary development in the Geneva Conventions that we haven't mentioned so far, is the enforcement scheme. The enforcement scheme that emerged in the Geneva Conventions is oftentimes referred to as the grave breach system. And the idea in the conventions, right, embedded in the convention itself, I'm not talking about background supportive guarantees in public international law. I'm not referring to some more general shift in our understanding of whether international rules can be enforced as a general matter via criminal law. I mean, embedded in the conventions themselves is this grave breach system. What is the grave breach system? The grave breach system says there are certain serious violations of these treaties, that when those violations occur, they aren't simply violations of international law, they are crimes. They're crimes. And we, the states that are ratifying this treaty, want to establish a kind of collective, a kind of cooperative law enforcement regime. We're going to work together to suppress this conduct. And the treaty obligates states to take certain steps. States have to amend their domestic law to criminalize the acts in question. The U.S., for example, has done this. So there's a provision in the U.S. Federal Criminal Code. Look in Title 18, Section 1441. There's a provision, war crimes. And the first category of criminal conduct specified in the War Crimes Act is grave breaches of the 1949 Geneva Conventions. Indeed, that's the full text of the prohibition. You want to know the scope and content of the criminal prohibition? Consult the treaty, right? Because the statute says grave breaches in the convention. But the idea is the U.S. is discharging its obligation to alter its criminal law to make absolutely explicit that certain serious violations of the Geneva Conventions constitute criminal offenses. Right? In addition to modifying domestic criminal law, states are obligated, when they have some good reason to think that an individual may have committed one of these crimes, to investigate, prosecute, and punish. And indeed, the provision goes on to state in a formulation that's oftentimes described as the prosecute or extradite formulation. States are obligated either to initiate a criminal prosecution or, if they're unwilling or unable, to extradite the individual to some other state willing to carry it out. A strong commitment to establishing accountability for serious violations of international humanitarian law shared by all states who are party to the Geneva Conventions. But notice, the conventions aren't setting up some international court to discharge this obligation. The idea is a decentralized enforcement scheme. We, the states of the world who are party to this treaty, will cooperate to suppress this activity through this kind of mechanism. You get the idea. Well, that vision has become something that is widely shared in the international community. The Geneva Conventions of 1949 were the first universally ratified multilateral treaties. Every state of the world ratifying the treaties. The crimes described in the grave breach system adopted in the statutes of multiple ad hoc international criminal tribunals. Adam referenced the ICTY, at which I had the privilege of working. Those statutes established by the UN, more specifically established by the Security Council, enumerating criminal offenses and included in the enumeration of criminal offenses what the UN characterized as the most serious violations of international humanitarian law, enumerated therein grave breaches of the Geneva Conventions. The International Criminal Court, now recognizing grave breaches of the Geneva Conventions and a whole host of related war crimes in Article 8 of the ICC statutes, a freestanding, true international criminal court established by treaty that I suspect we'll have occasion to talk about in the Q&A. An additional protocol to the Geneva Conventions of 1949 that was signed in the mid-1970s extended the grave breach regime outside the context of persons who had been placed at the mercy of the enemy in time of armed conflict, to include a range of targeting rules. So the additional protocol elaborated targeting rules, prohibition on intentionally directing attack against civilians not directly participating in the hostilities, a prohibition on intentionally directing attacks against the civilian population as such, prohibition on launching indiscriminate attacks, a prohibition on intentionally launching attacks that are directed against various kinds of installations and public works that are essential to the survival of the civilian population. The idea here is to hold the line on our fundamental conception of humanity, largely grounded in this distinction between civilian and those who are actively participating in the fight that had been so central in the Geneva Conventions in 1949, but extending it to the targeting context. And when I say extending the rules, I don't simply mean, once again, articulating the prohibitions, but also extending the grave breach system proper to that context. Violations of the targeting rules are also crimes. States have the same obligations. Those crimes are also recognized in the International Criminal Court Statute, have also been recognized in the ad hoc International Criminal Tribunal. You get the idea. What you're seeing in news reports is extensive documentation of illegalities along all these dimensions. Radical mistreatment of civilians who are no longer participating in the fight if they ever were. Indeed, individuals who have been made prisoner, summarily executed, otherwise subjected to cruel, inhumane treatment in a manner that would constitute a grave breach of the 1949 conventions, and a very broad range of violations of the targeting rules. Every day, more reports of what appears to be intentional targeting of civilian targets and the launching of indiscriminate attacks. War crimes. Two other things I want to say quickly, and then I want us to it will forever be 3:17. I've actually spoken for 0 time so far. So reassuring. Two other things to say. The first is there is a massive investigation underway on the ground and indeed in areas adjacent to Ukraine. Perhaps the most extensive war crimes investigation that I've witnessed in my career, made all the more remarkable that this investigation is occurring in the context of active hostilities. Remarkable. Investigation being carried out by the Ukrainian authorities, by other states, including some specially affected states. The UN Human Rights Council established a commission of inquiry, to their credit, almost immediately in the wake of the invasion, established a commission of inquiry with a team on the ground investigating the manner in which Russia is prosecuting the war. And it was that team that initially sounded the alarm for the international community about war crimes that were being perpetrated on the ground. We have good evidence, they reported, that war crimes are being committed. The evidence they were gathering on the ground married with intelligence. And I should also flag, well, the International Criminal Court has initiated an investigation here. This is something that I suspect might interest many of you, and I'm happy to talk about it. The International Criminal Court has initiated an investigation. They have a team on the ground. They have forged a formal cooperation agreement with the Human Rights Council's Commission of Inquiry. And you may have seen reports this past week that the United States is doing what it can to assist the investigation teams of the Human Rights Council and the International Criminal Court to document with the kind of meticulous care that's required if we're eventually going to carry out criminal prosecutions. Massive investigation that's truly quite remarkable. The last thing I'll say about the investigation is that many involved here are leveraging, if not outright relying on, the remarkably broad investigation efforts of a number of non-governmental organizations. So we've seen an explosion of what's often described as open source intelligence. Right? And this sort of collection and curation of this evidence is occurring on a scale that perhaps wasn't possible previously, but it certainly isn't like anything that I've seen previously. All of this suggests that over time, a terrifically compelling case will be made about the illegalities that have been perpetrated on the ground, and there will be, in some instances, very strong evidence tracing those crimes to specific individuals. Last thing I'll say, well, what do we do about this? What are the options for prosecution? And I just want to sort of gesture toward a few things here, because I suspect this is what some of you will want to talk about. What might happen here? Look, we could have national level prosecutions, and it's clear that authorities in many states are contemplating this. The prosecutor general in Ukraine opened an investigation into war crimes allegations almost immediately. You may have seen the news yesterday or the day before that she reported that they have evidence suggesting, I think it was in the neighborhood of 5,800 separate incidents of war crimes in the country. They are engaging in an effort with a view toward carrying out prosecutions under a statute they enacted to implement their grave breach obligations of the Geneva Conventions. Other states are doing the same, some with conventional jurisdictional hooks. So, for example, France learned that some of its nationals had been victimized in Mariupol. Based on a conventional kind of jurisdictional hook, France might prosecute individuals for war crimes in their courts under a statute enacted by France to implement its obligations under the Geneva Conventions. Right? There are other states that seem to be contemplating what we call universal jurisdiction. So they have no conventional kind of jurisdictional connection to the crimes that are being committed on the ground. They simply want to assert criminal jurisdiction in view of the fact that fundamental, universally recognized norms of international law are being violated. Germany and Spain are good examples, and there are others. Lithuania, Sweden, there are others. A number of states. And we can talk about some of what the United States might do as well. So national prosecutions are possible. In theory, it's possible for Russia to carry out prosecutions. I would not hold my breath on that. We also can rule out the possibility of an ad hoc international criminal tribunal like the one established for the former Yugoslavia and like the one established for Rwanda. Why? Because those tribunals were established under the authority of the Security Council, acting under Chapter 7, and owing to the voting rules in the Security Council, the Council can't take any affirmative action without the concurrence of all 5 permanent members of the Security Council. And for those of you who don't know, Russia is a permanent member of the Security Council. So we have 15 members of the Security Council. We could, in theory, see 14 vote in favor of an ad hoc international criminal tribunal. 1 vote against. The motion is defeated. You get the idea. That ain't happening. Another possibility, though, clearly is the International Criminal Court. The International Criminal Court does indeed have jurisdiction over the matter, and we can talk about how that's so. It's somewhat of a complicated argument, but they can validly assert jurisdiction over the crimes that are being committed on Ukrainian territory, and they have done so. An investigation has been formally launched, and indeed, we not only have the prerequisites for the exercise of jurisdiction satisfied, we now have the trigger for an actual investigation satisfied in the statute as well. Really quite remarkable. Just the short version of the story, since this is not likely something that you've encountered in conventional media sources. The prosecutor sought to initiate an investigation on his own authority. But in order to do so under the ICC statute, the prosecutor must seek and win approval of the court. So the matter would need to be calendared, fully briefed. Russia, other affected states would be given the opportunity to participate. The matter would be litigated, a decision would be reached, an opinion would be issued. It could delay the matter months, and there was concern. So the prosecutor, Karim Khan, at a press conference in Bangladesh, says, look, I'm going to move forward with this. This is, we're going to see what we can do. We had started an investigation some time back in connection with what happened in 2014. We're going to update those efforts. We're going to make a presentation to the tribunal. But look, all this is going to be delayed, and we're going to lose critical time. What would really help is if any state that is party to the ICC would refer the matter to my office. Because one trigger for the exercise of jurisdiction is if a state that has ratified the treaty sends a formal request to the prosecutor to open an investigation. Doesn't happen very often. Has happened half a dozen times in the 20-year history of the court, but it doesn't happen very often. But he issues this open request. Next day, 39 requests. Since that, now there are over 40 requests. States lining up to issue a request. It speaks to the sort of breadth of the commitment to holding Russian actors accountable here. So the ICC is a possibility. There are limitations of what the ICC can accomplish here, but we can address those in Q&A. I'll leave the sort of opening remarks there. I look forward to the conversation.
Great, thank you so much. I will forbear from doing the usual moderator's prerogative and injecting my own questions here. I did want to recognize two of our students here at UT. If you guys could briefly introduce yourselves, talk about your role. These are active duty military officers. Tom Morashevsky, both of them are my students, is an Army JAG, and Arnson is an Army officer. And you could talk about what you do in the military, and then specifically what your training provides. Tom, you as a lawyer in the Army, and Ed, you as just an officer. Also, I'd love to hear about what your enlisted soldiers are told about these things before they go into battle.
Sure, absolutely.
Ed, you want to go first?
Sure, absolutely. Good afternoon. Yep, good afternoon. So, Lieutenant Colonel Ed Arnson, I'm an Army War College fellow here at the University of Texas. I've been in the Army for 20 years. Served as a platoon leader in Afghanistan, and then twice as a platoon leader in Iraq. And so, specific to what we're talking about today, right, for soldiers on the ground, everything is governed by the rules of engagement. Right? Rules of engagement for our soldiers are going to be rooted in the law of armed conflict. And then specifically, I think what most people in this room and
can you tell everybody what are rules of engagement?
So rules of engagement are going to define very specifically for soldiers and for leaders on the ground when you can engage with the enemy and when you cannot. Right. So, for example, you're it's like a situation like I was in 100 times. Right, you're patrolling through a village in Afghanistan. Everyone is very friendly. Everyone is talking to you. You sit down, you have chai with the village elder, you leave, right? There is no course during that time, right, in order to engage the enemy, right? However, if you're patrolling through the same village, right, and perhaps from the hills, you're fired upon from Taliban or another group of fighters, right, you can obviously return fire. So it's all those types of instances. And all those things are spelled out. Soldiers down to the lowest private are briefed on those prior to going into any sort of a combat scenario, as well as those things get weaved into training, right? And folks like Tom, as a lawyer, are going to help make sure those things are very, very clear so that soldiers and leaders on the ground can act and, of course, keep themselves safe to protect civilians on the ground potentially. And then also engage and kill the enemy where appropriate. Okay, so that's how the rules of engagement really help soldiers and leaders that are on the ground. My experience is that all soldiers and leaders in the Army take this extremely seriously. And the cases that you may have seen in the news where it's not taken, where somebody did not take it seriously, or I should say violated those things are prosecuted to the fullest extent of the law. For myself, as it relates to some of the things we've seen in Ukraine now, right, which is civilian deaths on the battlefield, the United States Army, which is the perspective I can speak from, takes those extremely seriously. As a major in Afghanistan on a separate tour, I spent a month investigating several civilian deaths. That's all I did for a month, along with a team of officers. And those results went straight to the 4-star commander in Afghanistan at the time, General John Campbell, right, for adjudication. So those things are taken extremely, extremely seriously and then have consequences for those involved if it's proved that they acted right with gross negligence or with the intent to violate the rules of engagement. That's just a little bit of my experience on the ground and how the rules of engagement really help soldiers and leaders on the ground make decisions that not only protect them, right, protect civilians, but then also allow us to engage the enemy when it's appropriate. All right, so my name is Tom Rashevsky. I'm a major in the JAG Corps for the Army. I've done that now for going on 13 years. So if any law students in here are interested in talking about the JAG Corps, I get a free recruiting pitch out of this. Hit me up. I can tell you about it. I wouldn't be a good lawyer in the executive branch if I didn't give the disclaimer that anything I say is my opinion and not necessarily the opinion of the Army. So you can't hold it against me, right? So I'm free there. Two different things I'll talk about with you here briefly today to kind of carry over, and maybe we can differentiate between how the U.S. military treats the law of war and how it appears Russia is treating the law of war. And the first is the training aspect of it. So like has been alluded to here, we take training pretty seriously. It starts off when the soldiers are in basic training. They get a block of instruction from a JAG or a paralegal on law of war compliance. And it's pretty basic at that level, but these individuals are at a basic level. But before they are even officially out in the active Army force, they're receiving law of war training. Once they get to their actual...
What are they told? Do you give us some bullet points from that training?
Yeah, the bullet points, so I don't have them all memorized off the top of my head, but they have what's called the 10 Soldiers Rules. And it is designed to get at the core fundamentals of the law of armed conflict, right? So proportionality, necessity, discrimination, distinction. What am I missing here? Unnecessary suffering and protection of honor, like religious and cultural things like that. So those are built into these 10 soldiers rules that they are taught on. And then when they get to their unit, we do training again there on a yearly basis with them. And again, that's coming from a JAG or a paralegal. And then before deployment, they get specific training for wherever they will be deploying to. And when they're in that operational unit, the training they receive is a classroom portion, but we also encourage, and I'm fairly certain it has happened, we encourage the leaders of those units to incorporate into their hands-on training. So when we were going into Iraq and Afghanistan, and there was a lot of dealing with civilians, these soldiers would be out training in environments where they may encounter a civilian. And they have to deal with that. They have to apply, how do we handle this situation where somebody is running at me screaming, and I don't know if they have a suicide vest on, or if it is merely somebody who is extremely happy to see me, and I don't know what they're saying because it's a different language. So they get some of that applied in their training environments. And then, of course, when we deploy, they get briefed on the actual the rules of engagement that they have. And then whenever those rules of engagement change, which they tend to do for various reasons, they're briefed on that stuff again. As soldiers move up the ranks, their understanding of how law of war applies to their actions becomes more advanced. So it becomes less of a classroom environment when we start interacting with senior non-commissioned officers and senior officers, commanders out there, and more of like maybe like a C-suite conversation where you're talking to the CEO of the company, working through the problems and having an actual conversation. Hey, here's the issue we're seeing. How do things apply here? And that's kind of the role like I would have with Ed there, talking to him in more of that environment. On the ground in an operational environment, the Army puts JAGs at the brigade level, which is the 06 command.
It's about 4,500.
Yeah, 4,500 soldiers. Has a lawyer sitting in the room in the command center. If you ever see like a NASA moon launch where they get all the big screens up, that's kind of what it looks like. Big TV screens with satellite feed and things like that. And the lawyer is sitting in there working with the commander to, among other things, make sure we are doing things in compliance with the rules of engagement and ultimately with law of armed conflict. At the special forces level, it goes down to the battalion level, so a little bit lower if you're in the special forces world. So I'm probably way over on time, but I'm gonna give you a quick run through of what a law of armed conflict violation would look like from the perspective of the Army, at least, or the DoD. So initially, we would get some kind of an allegation, which could come from many sources, right? So somebody out there says, hey, we think one of your soldiers or somebody connected with you violated the law of war, whatever that may mean. And those could come from many different ways. It could be a self-report. Somebody could say, hey, I think I made a mistake. Somebody could say, I saw somebody else make a mistake. We are obligated to report that as soldiers. So if the guy on my left does something wrong, I have an obligation to report it, right? To say, hey, I think you screwed this up. It could come from news agencies, various non-governmental organizations are keeping an eye on what the U.S. military does. Surprise, right? And a lot of them report stuff to us. So the initial thing we have to do upon receiving a report is a credibility assessment. So we basically are looking to see, is there credible evidence, that is the standard we're looking at, that this is in fact true. Some of the stuff is way out there. I mean, some of the reports that we get are almost instantly dismissed. You know, they'll say, hey, you guys bombed a hospital over here, and we'll go, do you have any planes over there? No planes over there? The hospital's still standing? You know, instantly not credible. That's super easy to figure out. And of course, our enemies have figured out that this chews up time and resources. So they're quite happy to feed false narratives out there that use up a little bit of our time. The credibility determination could be a little bit harder to figure out. So ultimately, it's up to a commander, and they have tools at their disposal with the JAG to conduct basically what we call an administrative investigation to look into the credibility of this. Is there really some kind of evidence that this could be a true thing? If it is, so if that credibility determination comes out and we say, hey, we think this happened, it could go one of two ways. If it is merely a law of war violation, right, and not a grave breach, we don't have to handle it through our official criminal investigative divisions. So we have law enforcement agencies in the military. NCIS is the TV show that everybody knows. That's the Navy. We have CID in the Army. The Air Force has Air Force Office of Special Investigations. And they are professional criminal investigators. If there's a grave breach, it is on that criminal path. Those professional investigators are coming in, and we are looking at that with an eye towards prosecution through the military justice system. If it's something less than a grave breach, law of war violations could be varying scales, right? So it could be a soldier walked through a village and killed a villager's chicken for no reason. Just because he's angry. Technically, he destroyed some, you can see different scales of things that are out there. We handle those through administrative investigations if it's on the lesser side of things. And then we have options to punish that individual, for depending on what we found they did or did not do.
What's the most serious punishment that either of you has seen meted out? And then we'll go into Q&A.
Bales.
Yeah, the Bales case, right? So Robert Bales is probably I wasn't involved directly, but it was permeating the JAG Corps when that came out.
Most egregious, if you're not familiar with it, most egregious in terms of the number of civilians that he killed in Afghanistan, just in a village, and then is in prison for the rest of his life for it. So.
Thank you for listening to this episode of Horns of a Dilemma. And please don't forget to visit our website at tnsr.org.